What was the problem? Going to the meetings, you have to report, or else you're not on probation. You're not on my supervision. I don't know where you are. So you're not, if you're not reporting, that's the first thing you have to do. Yes, ma'am. So what are we doing about that? You gonna try to do that?
Yeah,
I mean, we help you. We help fix things.
Yeah.
Well, you got a great sense of humor about it. I'll tell you what. Hmm. And you, did you grow up in Vider area? And you've never been evaluated for any mental issues before? Yeah, okay. You're certainly taking all this well. Certainly find it amusing. Well, here's what I'd like. Like saying, stand by. Dr. Perpond evaluated her,
Just saying, just.
and she's confident. He knows. We did this in December.
I just want you to see for yourself. And
Right, but we did it for a reason. We had that done because everybody, I'm sure, convinced me that she is taking this seemingly lightly and giggles a lot, which I don't find that a bad thing. But well, there's not a lot of giggling here in this room,
No, sir.
except from the lawyers.
Just so that I can go tell my friends there's a woman hitting on me today. Sit down. So big.
I think she, like every other person on the planet, is just different. And it's not different to a degree that
I'm sorry.
the man I trust would find her incompetent. She's just different. So we all are.
Well, that's true.
All right.
That's absolutely true.
I don't, I mean, he evaluated her, and he always does a thorough job. She can understand the legal proceedings, has the ability to communicate with her attorney. Is not in need of involuntary inpatient psychiatric treatment. She did report some psychosocial problems because, and that she's something kind of like a transient, but just dealing with it. You know, all of this shows that she's unique, different, but that doesn't mean that she's incompetent.
That's true.
Or mentally ill. So we're going to stand by this since this was just a few months ago. This evaluation. You know, we've been through this before. You know, you're on probation for criminal mischief, and probation office is here today with us. You were placed on probation last November 17th for criminal mischief, and that was for 5 years deferred. You were not found guilty, so that's a good thing. But now we've got a motion to revoke probation that has been filed alleging that you committed assault, bodily injury in December, which was a month after you were placed on probation, then failed to report to the probation office in December and February. Let's see, failed to provide verification of performing community service hours. A special amendment here, an additional one, you failed to submit to a mental health evaluation as directed by the court. What do we have to do that? Can we do that? Get that done while she's in custody? All right, that's what we're gonna do, if you'd be so kind. So here's the problem is that any of those, if it's true, if it's proven true, then your probation could now be revoked and you could be sentenced up to 2 years in the state jail. How much time has she already had? Yeah, you can't enjoy being there. You want to get home, don't you? Me too. We're going to find out how much time credit you have. So Mr. Adams is here, is your attorney. You've had a chance to speak with him, right? How's that going?
Good.
Good. You understand everything he says? Good. He's a smart guy. He's a smart guy. So now you can either, is there an offer that's been made to
Yes.
try to resolve this?
Yes, sir.
Okay, but let me ask you, there's restitution involved here, right? It's criminal mischief. Restitution, how much is it? Or is there not?
I got on here, it says $3,150.
Is that for restitution or is that for just fees and other probation fees?
Well, they just, okay.
She don't have.
She doesn't have restitution. Oh, okay, all right. Well, you got that off your back. Have y'all tried to resolve it?
Yeah,
Under these circumstances, she's just sitting in jail.
The offer was 1 year. I tried to convey that to her. I don't think she understood that. And then I asked her about what happened with Orange, the case of Orange, and she didn't understand what was going on in Orange.
So what's going on in Orange? Do you have another case pending in Orange County?
I do not think so.
You don't think so?
She,
What,
because I
what did you
actually
found
wasn't
out?
disposed of, I was just still.
Did you find out? Well, so what's probation though?
I don't know anything. I just know.
Could y'all check on anything pending in Orange County that's above a Class C misdemeanor?
Yeah, she's arrested in Orange, December 18th for assault. She was staying at the Women's Center out there in Orange.
Oh, okay.
And she assaulted another, resident. And there she was released.
What they say? But I don't know how fast Orange moves on that, but I would think if it's something like that, they would follow, they move quickly, but could y'all look and find out?
Yeah, I can
Into
do
that, she's got 266,
Absolutely.
she's just sitting in jail, 266 days now.
Do you want to see if this move came back and they forwarded it?
You know what we need is to find out
That's what.
that and also this Orange thing, if what they're gonna do in Orange County. All that.
You don't know
needs to be
anything about
resolved.
Orange? Nothing about
No,
Have you ever been evaluated for any mental issues before?
no.
No, never? Yeah. How far did you go to school? Did you graduate from high school? You did? Where?
Butter?
At Vider High School? And did you go to college or anything like that? Ma'am?
Sorry.
Okay.
See, that's what I was saying, Judge, with the difficulty with being able to kind of communicate. And I was thinking it was more of a mental health issue, but that's why I want you to see for yourself.
I don't know. You're not Rapon and neither am I, but from the probation, the experience you've had with her,
I have never met her.
you've never met her. Okay. So what can we do? Try to resolve this motion, or set it for hearing from me, but she's on deferred or unadjudicated probation. Is there something, and these are, the thing that I guess is the elephant in the room is what's going on with the case of assault in Orange County. Can we,
I'll follow through on it.
I'm gonna give it 1 week just to check on it and come back.
Anyway, so how about
Thank you.
Monday?
We're gonna reset this 1 week. Okay,
Perfect.
Miranda, thank you. Get you rolling on this. Terrell Hopkins.
Let me get into.
Oh gosh, what are we gonna do? It's a motion to revoke probation as well?
Yes, Judge.
From the judge, that's fine.
Is there a?
She has a DWI third that's set next week. The state would prefer to try that one first, and we should be able to resolve them both together. But Langston is representing her on the DWI.
Okay. This is a state jail fellow. Hmm. How many prior convictions? Would you like a calculator? I mean, she's your client. How many prior convictions does she? Yes, Rose. Raise your arm where you Rose, please. Stan. Fine. So this is state jail felony. It's punished as a second degree felony, right?
Yes, Judge.
What's the other one?
She's a DWI third that's punished as a habitual felon status. We would prefer to try that one. It's set next week on the trial docket. I'm not sure why they weren't set together.
How's it?
Okay.
So I knew she was doing.
I like that idea too.
Langston is representing her on the DWI third.
Is he ready? Or is he gonna be ready?
He's here.
I just saw him, I'm not sure,
All right.
but that's set next week. It's not nearly as old.
Okay, Cody Hatch, you ready?
Ready on that.
All right, then
Yeah.
that'll go. Jonathan Cruz, Jonathan
Are you ready
Cruz.
on that?
Yes, sir.
Okay.
It says Crenshaw. He's not on that?
He is.
Oh, okay, all
We're
right.
we're a
Okay.
team, Judge.
Yeah, y'all could do more damage that way.
How we like to say. But we're ready.
All right, Jonathan Cruz
State's ready on that one, Judge.
and Robert Glasper.
State's ready on that one as well.
Wait, you're, oh,
Judging a little bit, can you, Jonathan, freak out?
why?
Watch him and everything, because it's a kind of situation where it's pretty much time to just make sure he knows that it's.
Well, yeah, I'm sure you, I know.
He's in red.
He's what?
He's in red.
Oh.
And watch where I say I had people on me, so. There's a little few issues there, but. That's not, I think we can do. We should have, just. Got one.
Okay, it's a state jail, punished as a second degree felony, right? These two prior convictions that are in sequence. So it's up to, he had that. Is it still there?
Well, now, Judge, if we could keep it as a state jail felony, he's done the time for it. So I would,
Wait, is that what y'all are proposing?
yes, sir.
How much time? Can you give me, Jonathan Cruz calculate? Thank you. Good time. Look at this one going on right there. Organized crime. Conspiracy. All goes with it. Look at them go. What kind of a plan are y'all hatching?
It's a great strategy,
all-
Judge. We'll tell you what it was.
Should we all be scared and running for the hills?
Not on my case.
Once the trial starts, we'll tell you.
Need my graduation.
Yes.
Okay. There's John there. He doesn't ever pay for gas and siphons everybody else's tanks. Got a big siphon hose. I got to talk to you about a couple of things, but the big one is on Jessica Wright. Yeah, I think what I've passed on that, you got her next week.
Okay.
And isn't that right?
Yes,
And
Judge.
so I think she's going to be number one next week. As the felony theft, yeah,
Oh,
it was Kimler's, but he says you got it, man.
She's.
Right is on,
Can you call the name? We haven't seen her.
yes, she's not.
for DWI.
Yes, Wright
Yes,
is representing her on the theft.
This is a theft, but we're passing that because the DWI is a more serious matter.
And I think the case got separated because she's two separate attorneys, so you probably didn't realize she was the same person.
Is Jessica Wright here?
Yeah.
Jessica Wright?
She's here. I just talked to her today. I'm 100% sure she's here. And she's checking in my misdemeanor court. She's here.
Oh, she's in misdemeanor court too?
Yeah, I'm 100% sure I just talked to her.
She needs to be in here though, so we can make sure that she is actually here for the record and so that her bonded or
Okay.
no, I'll give her some time to get over
I'm
here.
100% sure she did. I can go get her real quick. Hold on.
Oh, you don't, when she's through, just come on in and so
Okay.
we can, and also she knows because we're gonna set y'all number one next week.
I didn't know that.
Yeah, well, it's 1,000. I'm trying to get rid of all these 1,000-day cases.
Just for clarification, the DWI third is
But it would, you're thinking it's gonna all pour down.
Yes, we
Yeah,
should be. I need to speak with Langston. We might be able to work them out without a trial judge. The DWI is significantly young.
All right, John, Ricky Turner's next.
Yes.
No, he's on.
Oh, ready, Jeff? Oh, it's theirs. Get my flags out on that.
Ricky Turner? Ricky Turner is called 24 CR 2444.
You may take it.
There's no answer in the courtroom. I ask the bailiff to call into the hall, please, for Ricky Turner. No response to that name called here in the courtroom. No response to that name called into the hall by the bailiff. Defendant has failed to appear. And what we're looking at is, this isn't good. Oh, it's a third-degree felony, unlawful possession of body armor. I don't like to know what was behind that. Oh, is he in custody? There he is. We were talking about you. Okay, you're Ricky Turner?
Yes.
Okay, you're set up on the trial docket here, and as you know, you've got this third-degree felony of unlawful possession of body armor, metal, which is up to 10 years in prison, but you've got those two prior convictions that are in sequence that make you 25 to life, a minimum of 25 years in prison. You understand that?
Yes, sir.
What are we doing?
Your Honor, I didn't know
And
he
he's
was
not eligible
here.
for probation
Right.
because you've got,
I talked to him a little bit because me and Mr. Laird talked about this case, and I think I have read
How'd that
possible
go?
resolution. Right, I always have fun with Mr. Laird. It's always,
well, was Mr. Turner involved in it?
he was not, and I didn't know he was in custody.
He's
I
kind of
haven't
a
been able
mean
to,
person.
I haven't been able to get in touch with him at that because I didn't know he was in custody. So because he was out of custody last time we
Okay, well,
talked.
y'all talk, let me know
Yeah,
where
yeah.
that's headed.
I'll let you know. Yeah,
Thank you.
yeah, I thought of it. Okay.
Okay, that's where we got a little asterisk there. Jameisha Butler, please.
But we received an email from the bonding company. She is not gonna be here this morning. I printed out the email. Apparently she was flying in from Miami at 6 a.m. this morning and missed her flight.
Yeah.
That's the information I was with.
Judge, we were going to ask for one more reset. He gave me a mitigation package that I need to go over with the officer that was injured in this case and see if he changed his mind or if it has any effect on my officer.
I understand. The only problem is on this, how do we really test? Okay, she missed, I mean, that's her word. And how do we know what, no, how do we know what really happened?
I
We
think she
don't.
did supporting documentation with regard to her flight schedule and all that. I think that was sent over to the planning.
No, her license, but who's responsible for that? Not me, not
Well,
you.
I would
not
agree,
anyone.
I would agree.
I
with
mean,
that.
everybody else has to be here one way or the other. You got to figure it out.
Judge, I would agree with
I
that.
wouldn't be flying in the morning of the docket, quite frankly, because there might be a problem on scheduling. I'd have been here a couple of days early just to be on the safe side. That's just me, but the docket is a docket, and I just heard that. Here's what I'm going to do. Give me whatever information you can get me, but on Mr. Butler. It's the memo. Do you have this? I'm gonna give you a copy. This is from the bondsman.
Well, I did, they forwarded me the email. I've been on the phone on this one.
Have you read this?
No, sir.
She was on vacation up there. Missed the trial docket because she was
Judge, if I
spending time on
may, if I may, she and I, well, no, she and I have had some pretty substantial communication issues. I've actually reached out to
But they
her.
weren't with me.
I'm sorry.
They weren't with me.
I get it, but you know, she's never missed court. She's never been late. And I don't think she was just, disregarding the purpose of the meeting.
See, okay.
If I could show you the text that she sent me, it was pretty animated.
As far as at Bush, our flight is scheduled to. wasn't able to change her flight for her and son's. Her car's at Bush and our flight is scheduled to land at 8 o'clock. I don't know what that means. The phone does at 6:12. She missed her flight. I don't know how she was going to get to Bush International and get here at 8. Bid her for 9
I
o'clock.
can't answer that. What I can say is that, we've had some communication issues and I'm not quite sure that she.
I forwarded previous and new flight schedule. All right, what we're gonna do is, so when's she supposed to be in Beaumont?
Hopefully within the next 3 or 4 hours.
Okay, well, yeah, so let me just put this in the suspense. And when she gets here, then we'll have a hearing. We'll have a hearing on it, on where she was and all that.
Do I need to stay until she gets to, I need to?
No, we can call you.
Okay.
We'll call you if that's okay.
So she needs to come to the court.
Yes,
She arrives.
yes, so I know she's here and she's really here, and then it gives her explanation on the record, and then
But then
what
okay.
can you do? You know,
Okay,
those things can happen.
And my excuses this morning.
Yes, sir.
Okay. All right.
Thank you. Ryan, Magby, John.
Yes, sure.
So that, and we had 2 cases, didn't we?
Yes, sir.
Yeah, yeah.
I need to show you something.
Judge, I'm gonna ask for a special
You know
setting.
what, what's interesting about that, Mr. Constant, what's interesting, she's not here. What she's charged with is evading detention and escape.
I know, Judge.
Should I be worried?
I like to think this is unrelated to that. I think this is a continuation.
What are the odds of that? All right, Ryan Magby.
I'm gonna ask for a special setting on that, Judge. It's a set of guys who do a YouTube channel called Predator Poachers. And
That's this guy?
that is the main witness in the case.
They're the ones discovered.
They discover child predators around the United
Okay.
States, so they are traveling.
But they're not the ones charged.
No, sir.
No, they're the complaining.
Okay.
Yes.
All right, so
And there's more than this case. There's more than one case.
okay, this is a 3rd-degree felon. He's a habitual felon. He's looking at 25 to life.
He has 2
All right,
more.
he's certain
cases.
about this? What he wants, he's gonna go to trial?
But there are 2 other cases, Your Honor, and yeah.
All right.
But
Oh, yeah, and there's 2 others.
there's 2 other cases that are on. Is it
She's
2?
got 3 shots at it.
Is it 2 others? Yeah, I know. 3 total. Yeah.
And what was the offer? I'm just curious what he's giving us. 25 to life.
Yeah.
Do you know? You don't know?
Top of my head, no. I have it written down in my computer, but
Yeah, when we get around to it, let me know.
yeah, I'll let you know. I have it, but I don't.
David Scott.
Mr. Scott.
So we've set that to when? Like,
Oh, that's up to the state.
If you can just give me, if I can, or I'll get with the courts coordinator, or I can get a specific date that way, because these guys are booking in different places and
Other jurisdictions too.
yes,
they made a mess everywhere.
Yeah.
yes, sir. That's
David-
pretty much it.
David Scott.
I didn't know those topics.
David Scott?
Oh, Scott, okay, never mind. Yeah,
The state's ready on that one.
we were ready, but I do have an offer on the table. I do want to make sure
Well,
before we.
Today is a good day to consider that because it's Fisher Cut
I got
Bacon.
some other information from the state this morning. Or email some information. Okay. yeah,
Michael Osborne?
Judge Hutchinson is pro se, we need to put him out.
Yeah, okay, but we're gonna bring him out last. Because I understand that's always a spectacle.
Yes, Judge, we still need to share discovery with him.
Clayton Easton? On Clayton Easton? What's happening on this?
Even though I'm ready for trial on the short case that we talked about earlier.
Yeah, I don't know.
This is going to be a much more extensive case. And so I've got Rusty Duncan on Thursday and Friday for this week.
Okay, it can't set off long. It's almost 900 days old. Okay, okay.
Well,
And
we
for
need
something
to-
like this,
so the
this was
judge-
supposed to be fast tracked along.
Motion.
When can y'all be? Let's set it now for a special setting. 4 weeks,
That's fine with me, Judge.
good?
Um,
Yes,
Not
that's
really,
you're
Judge.
saying there, but you mean yes.
I don't, yes.
That a
I would
yes?
assume that would be the week of the 13th, and then I'm gonna be gone,
How about the week before that?
the week of the 6th. Yeah, I mean theoretically,
Theoretically, what?
I could do it the week. of the
Okay,
6th.
July 6th. Is that right? What the? Okay, July 6th. It's on Saturday. Okay, July 6th. Get a resetting. Let's put that one first. Thank you. Michael Jackson,
Marcus Jackson.
Marcus Jackson. Like I've seen that. Marcus Jackson. That's Mr. Wilkerson. Okay,
Oh,
he's in jail.
He called in sick, Judge.
Okay, reset 1 week. Thank you. Patrick Peshon, Langston, and Andre Madison Langston. Todd LeBlanc. Hey, well, so you're two. Are you ready on? You're ready on Glasgow, right? And Jonathan Cruz, you're talking to him about.
He's in custody now.
Okay, and Glasper, you're ready on that one.
I'm here.
Hey,
I'm here.
okay, so your number, Cody Hatch is 1, Glasper's 2.
Second.
How are you?
I'm here. Okay.
You've got Heshoff and Madison on the
Right.
chart, on the docket. What are you gonna do?
Both of those is, when I just talked to them, they both saying that they didn't want the offer.
Oh, okay, so then Heshoff's gonna be, okay. I've got Hatch, Glasper.
This office, that's it.
John, what do we do on Davis Scott? John?
He's gonna
He
talk
said
to
he
me.
wanted to talk to him, but
Heshoff's 3, Madison's 4. Okay,
Bring
Should
out
we-
Mr. Osborne to talk to him.
no, you do that. Let's bring out Michael Osborne and everybody hold on to something. Who's on this? Who's the prosecutor on this?
oh, which one, Judge?
Osborne?
That's Ms. Gonzalez. That's my good hair.
Good morning, good morning. Good.
Stand by.
Name.
You or Michael Osborne?
Want
Miss
to know?
Jasper? Miss Jasper. All right, what does it take to get this thing to trial?
We need to share discovery.
You need to
with
share
this.
you and he? Or you and he?
We need
Well,
to,
I need to network with the record because you're not doing right. You know
Man,
that.
sir, this isn't criticism day.
Next time we
I'm
got
sorry,
to,
go home. You're in, you
No,
can't speak
I
over with,
said,
go home.
Judge,
You
I'm
did it
about
again.
to have you
You did it
recused.
again.
You know
I'm out.
that. Go, man.
That's
Get your
rude.
head off
You
me.
can't, don't do that. We had that last time and you were awfully rude and you're still rude. Yes, Mr. Rude. Gosh, bless you.
Judge, for the record, the last time that this was set, there was an attorney on the case, so we just need to schedule a time to get him discovery. This was his first pro se appearance.
What do you have to do? What can you do to get that?
We'll just need to coordinate a time with the jail to bring him over to view the discovery in this case. We just haven't had a chance to do that yet.
Can you do it this week?
Potentially, it depends on if I'm going to be in trial or not. But we will get it done
Okay.
so that we can proceed.
On the discovery, please send me a copy of all that as well.
Yes, Judge, I'll have to get it prepared.
Thank you. Yeah, yeah. Same thing every time. He criticizes and controls and we're not getting anything done, but it's 200 days old, so It's not as old as the two 1,000-day old cases. But for the state, please get that over to him and send me a copy of it, verifying that was done, please. So we got Cody Hatch, Robert Glasgow, Patrick Peshoff, Andre Madison. Thank you.
Yes.
And then Ricky Turner, Jessica Wright is reset 1 week. Special set next week for that. Get rid of all those 1,000-day-old cases.
You want half of the stack or the stack?
Miranda.
You Miranda Bowling?
Mhm.
If you, come on, I'm gonna judge on her, you'll see. Come on, let's go.
Here's this.
She's not.
Get this indictment. Oh, boy, we got priors. Prior robbery.
Judge,
Mhm.
on Mr. Hopkins, come on, stop. No, over here.
You're Mr. Terrell Hopkins?
Yes, sir.
Yeah, here in cause 22-39026, there's a motion to revoke unadjudicated probation for unlawful possession of a firearm by a felon. You were placed on 10 years deferred of unadjudicated probation. It's a few years ago now. This is going on 4 years. Anyway, this states they filed this because you failed to report to the probation office. This states on or about October 21st, the year was 20,225. We gotta fix that. Did I miss something or did a few years pass?
Yes.
Okay. And then November 3rd of 2025,
Mhm.
which was more or less realistic, December, January. So you were missing these monthly and you weren't reporting, which is the most important thing to do is to report, or else you're not on supervision, which is what this is all about. And people think that's not important, but it is the most important thing. There's nothing we can do to help fix this mess that you got yourself into because of your inattendance. You got, I'm looking at a 1988 robbery conviction in Michigan. Then you have the illegal possession of a firearm, and it states that you have that conviction out of another conviction out of Oakland County for illegal possession of a controlled substance back in 2010. So you've got that 88 robbery, then the 2010, and then now this new charge, which is a third-degree felony in paragraph 1. But because of paragraph 2, that robbery conviction, the way they pled it, this third-degree felony is enhanced to a second-degree felony. So you're looking at up to 20 years in prison if convicted. Okay. And you're not eligible for probation in front of a jury if you try this. So where are we on this?
Just where we were, I know the offer was 4 years, but I believe we came to court on the 1st. And I think the motion to revoke hadn't been filed yet. And I think you reduced his bond to $10,000 because he reduced the bond. And I believe the state has filed a motion to revoke what you said on 3rd, right? 3rd, 4th.
Yes, this was filed on June 3rd.
It was filed on June 3rd after our court date on the 1st. So what I guess where I am with him right now, Judge, is
what would you like to do today? It's early, but he's sitting in jail. This ought to be something y'all might be able to work out, but maybe not. I don't know. I just want to give you a few weeks to do that.
That's perfect. We'll try to put it together.
2 weeks good?
Perfect.
Yeah, okay, let's see where we are, sir.
wrong with that?
Sir?
Personal comments, bonds?
No, sir. Not when you're looking at this. These multiple charges from the past and now. And you're looking at the failing to report.
I reported the Honor.
This, well, the state says you didn't on October 21st, November 3rd, December 5th, January 6th. Which their monthly report.
I was in a rehab. She knows this.
Well, it's not, this isn't the hearing on the debate.
Sorry.
Judge, it was my understanding from speaking with probation that he was ordered to go to safety after the administrative hearing and then did not report to safety, which is why we went ahead and filed the MTRP.
That what happened?
Yes.
Okay, why didn't you report to safety?
Because I take certain, like I was telling you, and then she told me it was 6 months to go to St. Pete, right? And then I was informed that until you take that medication, you can't just do 6 months. You would have to do
Who
six.
told you that? Who told you about the medication?
Everybody knows this.
Everybody?
They says.
Oh, these people are giving
You do 9 months of St.
medical
Pete.
advice to you who you don't know?
It's a law that you got.
I know what the law is.
It's 9 months of St. Pete plus
Oh,
3 months.
I know all of this.
Plus 3 months and a half warehouse.
Now, I know that here's the problem. Once again, is you failed to report, which is the most important thing to do. That's what this states, and that's what this hearing is going to be all about. Is your failure to report on all these months. That's since October. I mean, you were essentially, we call that an abscondence. You were on your own probation, which really shouldn't be. You're supposed to be supervised. And if you don't report, you can't be supervised. It's the most important thing. That's why it's always, I mean, in your probation order, you remember receiving that. Report is directed right at the top. You're supposed to report at least every month. And we had to go find you somewhere. And that's what this hearing is all about. When can you do it? All right. All right.
Thank you, Judge.
Jesse Mason.
Yes, you should be right up.
What's going on this one?
This is still all right. But the rest of them, they'll use that.
I'm sorry.
So the rest of the cases will be pleased after that.
Jesse Mason?
Mason.
Yeah, Jess. Thank you. What?
He's being the bailiff.
Langston, being a bailiff today, too?
He's
Was he doing that for some extra bucks?
Could be.
Is that a supplemental income? Look at it. Just like the bailiff. Thank you. Good work. Kendall, relax. Langston's doing all the bailiff duties, right?
Not bad. Hey.
It's taking over. That's right. Are you Jesse Mason, sir?
Yes, sir.
In 26 CR 446? Hello. Okay. You're charged with the state jail felony of unauthorized absence from a community correction facility. Was this one of those things where he was released for visitation or something? And since he left the center as intensity of knowingly leave said center as directed by the court and the community supervisor and without the conscious approval of second order. Right. What? So then in there while he was required as a condition of community supervision. Required as a condition of community supervision, required as a condition of correctional programming. I know that makes sense. To submit to a period of detention and treatment in a community correctional facility, namely Beaumont Center. And you intentionally or knowingly left said center as directed by the court and the community supervision correctional. That doesn't make any sense. And without the approval. So it says that he intentionally and only left said center
Judge, I
as
agree that
I'm just reading the indictment.
yes, I agree that the wording is interesting and the facts on this are a bit unique. I believe that the indictment is alleging that he was supposed to be in the center as directed by the court and community supervision, and without approval of the court and community supervision, he left the center.
Well, it says that's not the way it reads.
Yes,
says
we can,
intentionally or knowingly leave said center as directed by the court. I didn't direct him to leave.
no, Judge, we can get that fixed.
Yeah, this is the wording's bad on this, sir. We're trying to, first thing is, it doesn't matter until the indictment is fixed. That's the most important thing. Everything flows down from the allegation, and the allegations. It's alleging up at the unauthorized absence, but the body is confusing and it needs to get cleared.
Yes, Judge, we will go right on that.
The thing is, you've got those 3 prior convictions in January of 22 for out of Gregg County, which are terrible things. This is a state jail felony, but if all of these 3 convictions are true and you're convicted of the correct wording that was intended based upon the offense as alleged, then this would be a state jail felony, though punished as though it would be a 3rd-degree felony. It gets enhanced 1 level because of the 3 prior convictions. And the thing that helps you on that is that these were 3 convictions on the same date. So you can't stack them because they weren't in sequence of dates. But it's still a state jail felony punished as a 3rd-degree felony. So you're looking at up to 10 years in prison, which is never a good thing. And you're not eligible for probation in front of a jury because these allegations of prior convictions are in the indictment. And if 1 or more of them were true, that wipes out a probation qualification for you in front of a jury. So that's what I think we're looking at, right, Don?
Yes, Judge.
Okay. She needs to repair the indictment.
Yes,
Can you do that in 1 week?
we can try, Judge.
Well,
I'll get it to intake today, but
thank you.
Judge, he's also asking that regardless, it'd be set for trial, that I be relieved so he can get to court with him.
You be relieved for what?
That I be relieved.
So he can be pro se?
No, sir. He wants another attorney appointed, so it can be resolved
No.
with a matter.
Don Dusler, I've known Don Dusler my whole career. He's a fine lawyer. You can go hire anybody you want. But I chose him as one of my public defenders because he's competent and he represents his clients. I've known him for 40 years. And but you can hire anybody you want, but you don't get to pick the appointed attorneys. That's not the way it is, sir. Sir, go ahead.
I am requesting another.
Okay, you're denied. Denied. You are entitled to a competent attorney, and he is one. I haven't heard anything to suggest he's otherwise, or that there's a problem between y'all two. That's the way it works. You can understand if it was otherwise, let's say we have 3 public defenders or 4, and then everybody decides they don't like 3 of them, then one person would end up doing 1,000 cases. That wouldn't work. But they rotate, and sometimes you may disagree with them, but I was a lawyer, private lawyer for a long time, and sometimes people didn't agree with the advice I was giving. But you're entitled to know from legal expertise what you're facing, the pros and cons. At the end of the day, it's not his choice, it's your choice on how you proceed, but you don't get to choose the attorney when it's an attorney that's appointed to represent you if the attorney didn't do anything inappropriate or unethical. Don doesn't do that. He has a good reputation. Let me just rotate this a week so we know where everybody stands on what the defendant wants to do
Yes, Judge,
On
we'll
this.
get that indictment.
This needs to be, you can correct it.
It'll likely have to be re-indicted
Yeah, well, that's what they do on Thursdays, right?
Wednesdays. Yes.
I see.
Yeah.
Okay.
I'll do
And
that
then we'll do this back on Monday week and see where we are on that, okay? And see if there's a way it can be resolved without a trial, and then if he wants a trial, he'll get a trial, and then it's one of the trial lawyers.
Can I speak?
It would be different from him. Yeah, you can speak.
Your Honor, when I arrived at the police station to turn myself in, because I realized I had made a mistake, I learned that the blue warrant had not been active yet.
Okay, hold on.
And
You're talking about the facts of the case, right?
To the halfway house.
Yeah, hold on. You're talking about the facts of the case. And number one, unless you're going to ask me to be the judge and the jury, you're going to have a jury trial if you want a jury trial. But right now you're talking about facts of the case, and I'm not the fact finder for whether you committed a crime or not. That's not what we're here for today.
I was just trying to tell you.
There's nothing I can do about change.
Arrested.
Okay, sir, there's nothing I can do
They didn't
about it.
read me my Miranda rights.
Okay, all right, that's something you tell your lawyer, and that's brought up in front of the court or the jury if that isn't part of the element of the crime. But that's not anything that really I can do right now. But that's where you pass all that, then that gets brought up during a trial or doing a pre-trial hearing, and then the court or a jury would make the fact issue determination, and then your life proceeds in that direction. But right now, that's not there's nothing I can really do about what you're saying. First thing is the indictment needs to get corrected.
Yes, Judge.
That is,
Get on that.
it's clear. Okay, and then we said 1 week and see where we have gone from there. Okay, sir? Don, thank you. Don, I've got Sergio Preciado, that's reset.
It's been reset. We're waiting for an interpreter, and I think next week we're gonna have one here to do this.
I have Martin Romero.
Same pieces.
Okay, how about Robert Simpson?
Ready to go on that.
Robert Simpson, what are we gonna do with him?
2 cases, please.
Robert Simpson?
Yes,
What about a motion to revoke probation and then a new case, correct?
that's correct.
Hey, Langston, don't leave before I see you, okay? Because I got something for little Langston in the back.
Yes.
We're back. And you are Robert Earl Simpson. And there are 2 cases. Motion to revoke probation is on the older case, 21-38166.
Yeah.
You were on probation for, looks like theft of metal, some sort of state jail felony. And now you were placed on probation in February of 23. Subsequent to that, a new indictment has been filed as of December of last year, a state jail felony hindering secured creditors. Hello, we've got some prior convictions here on this stuff. State jail, state jail, state jail. They're all state jails though, right?
Yes.
Okay. Well, that's good. They're not 3rd degrees or higher, which would really bump this thing up. So what are we gonna do today?
We are pleased, 18 months state jail.
In both?
Yes.
When on the motion to revoke probation,
Yes, sir.
is, are we gonna use this,
Yes, sir.
count 1?
Yeah.
All right, does the defendant, and you are Robert Earl Simpson Jr.
Yes, sir.
here with Mr. Dusler, your attorney and the state's attorney. Does the defendant waive formal readings of the motion to revoke probation in 21-38166 and the indictment in 25 CR 1914? Can we proceed in silence?
Yes, sir.
And sir, raise your hand. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth? So help you God. Lower your hand. In summary, on this motion to revoke probation, this motion states in paragraph 2 that on February 23rd, 2023, in this criminal district court of Jefferson County, Texas. You were sentenced to 2 years in the state jail, and that was suspended. You were placed on regular probation for 5 years for theft of material, metals. And it looks like it was copper. And that was a state jail felony, and you were placed on probation at that point in time. Is that true, sir?
Yes, sir.
Allegation one states what this indictment states in 25 CR 1914, an indictment handed up on December 1st of last year. And allegation one states that you committed the offense of hindering secured creditors of an amount equal to or more than 2,500 and less than $30,000 on or about April 1st, 2025 in Jefferson County, Texas, which is a state jail felony under this indictment 25 CR 1914. And it looks like it involved an automobile. All right. Do you understand what this alleges, and is this allegation true and correct as it is alleged?
Yes, sir.
Are you pleading true voluntarily and because it is true?
Yes, sir.
Do you understand that voluntarily and knowingly made plea of true to one or more violations of probation, that is enough to grant a motion to revoke probation? Your probation can be revoked, and you can be sentenced to no less than 180 days up to 2 years in the state jail. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true to allegation one of this motion to revoke probation. Now, if I was just clairvoyant, I'd know what the deal is. Thank you. Thank you very much. Made this easier. An agreement has been reached here where you would be sentenced, your probation would be revoked, and you would be sentenced to 18 months in the state jail to run concurrently with this new indictment, 25 CR 1914. Is that all true and correct, sir?
Yes, sir.
I intend to follow this agreement. If I do, you have no right of appeal of your case. Do you understand?
Yes, sir.
Today is
15.
15. I show you what's marked as State's Exhibit 1 on this set of papers. Did you sign that document, understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered and
No objection.
without objection admitted. This states that you are giving up all rights of appeal if I follow this agreement, which I intend to do so. If nothing further, I'm going to find that there is sufficient evidence supporting this motion to revoke probation, to grant it by a preponderance of the evidence or greater, as the defendant has pleaded true to allegation one of the motion to revoke probation, committing the offense of hindering secured creditor, which is represented in this new indictment, 25 CR 1914, state jail felony. That is enough to grant this motion to revoke probation by a preponderance of the evidence or greater. It is granted, and your probation is hereby revoked. That was earlier placed into the record, and for which you were earlier sentenced on this theft of material. Now that your probation is revoked, I am following this agreement. You are hereby sentenced to confinement in the state jail for a term of 18 months. You will be given credit for all time you have served in accordance with that case. Now let's finish up with 25 CR 1914. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes, sir.
In summary. Summary, this indictment alleges that on or about April 1st, 2025, in Jefferson County, Texas, you committed the state jail felony of hindering a secured creditor or creditors involving a 2005 Buick automobile. Do you understand fully what you're charged with?
So,
This is a state jail felony which carries with it confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
so,
An agreement's been reached in your case where you would be pleading guilty and sentenced. Is that an 8?
yes,
Hold on. I'm going to use the Arabic numbering system that we commonly use. What happens is when you write on these pads, sometimes the numbers come out funny. Put a number that looks just like a snowman. Okay. An agreement's been reached where you would be sentenced to 18 months in the state jail, which would run concurrently with the previous motion to revoke probation that you were sentenced to a few minutes ago today. Is that your understanding of the agreement?
yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this indictment, sir? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
We'll show you what's marked as State's Exhibit 1 here. Did you sign that document, understand it, discuss it with your attorney, or the contents true and correct?
This opinion, Judge, just one spot didn't get signed.
State's Exhibit 1. Did you understand all of this, and is everything true and correct here?
So,
State's Exhibit 1 tendered into evidence
No.
without objection admitted. This states that you are mentally competent to enter your guilty plea, which freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. That scares me. All three of those guys walking back there. That you are mentally competent. Your plea is freely and voluntarily made. You understand and appreciate the consequences of pleading guilty. You've read the charging instrument, or it's been read to you, the indictment. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial. All of this is true. It states, so help you God.
yes, sir.
State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is hereby waived. I will follow this agreement. And again, you are pleading guilty to this crime, and we're not using the priors. It's just allegation 1, paragraph 1 of this indictment, the state jail felony. You were pleading guilty voluntarily to this state jail felony and cause number 25 CR 1914. There's sufficient evidence supporting your guilty plea from State's Exhibit what admitted there to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this state jail felony. I'm following this agreement. You hear my sentence to confinement in the state jail for 18 months. These sentences will run concurrently with each other. Do you understand what has happened today, sir?
Yes, sir.
Anything else?
No.
That is all. Thank you. Here he goes. Thank you. Tanya Wells. Yes. Tanya Wells. Thank you. Yes, we do. Thank you.
Pick up right first.
Please raise your right hand. You swear or affirm to tell the truth, the whole truth,
What's all right?
So. And we call 26 CR 530, the state of Texas versus Latanya Ann Wells. You're Miss Wells?
Yes, sir.
And you were here with your attorney, Mr. Dusler, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
In summary, ma'am, this indictment handed up on April 1st of this year. That should say something right there. It alleges that on or about February 25th, 2026, in Jefferson County, Texas, you committed the second-degree felony of aggravated assault by threatening someone with imminent bodily injury, and you exhibited a deadly weapon, namely a knife, that in the manner of its use and intended use is capable of causing serious bodily injury or death, which is the definition of a deadly weapon, and that was during the commission of the assault, and is signed by the grand jury foreperson. Do you understand what you're charged with here, ma'am? Here we go.
To the best of my ability, but not quite fully.
What don't you understand? Let's all buckle up here.
Did I hurt anybody?
You don't have to, well, you don't have to, you don't have to harm anyone, but there's harm. There's harm. It's understood that if someone is threatened with a deadly weapon, namely a knife, then there's going to be harm to them because they're in fear that something bad's about to happen to them. So that's the harm. This is a second-degree felony, which means if convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached in your case where you would be pleading guilty and sentenced to 4 years in the institutional division of the Texas Department of Criminal Justice prison. Do you understand the agreement, ma'am?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge then? Guilty or not guilty?
I plead guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir. I plead guilty.
Okay, I'm going to show you here what's marked as State's Exhibit 1. Did you sign that document? Understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence
Okay.
and without objection admitted. Among other things, this states that you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you're totally satisfied with the representation provided by your lawyer.
Yes,
All of this is true at state, so help you God.
yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is
Yes.
waived here.
Yes.
Ma'am, I'm going to follow this agreement. I'm going to find that you are indeed mentally competent to enter your guilty plea. It is freely and voluntarily made. There is enough evidence supporting your guilty plea from State's Exhibit 1 here to find you guilty beyond a reasonable doubt. And you are pleading guilty today voluntarily, knowingly, intelligently, because you are guilty.
Yes, sir.
Yes, well, what you're charged with here.
So,
I now find you guilty beyond a reasonable doubt of this second-degree felony of aggravated assault with a deadly weapon. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. And the judgment will reflect an affirmative finding that a deadly weapon, namely a knife, was used in the commission of this offense. Do you understand what has happened today, ma'am?
yes, sir. It was a pocket knife.
Yes, ma'am.
Moved in pockets.
Well, they can do damage.
Yeah.
To someone, you stab them in the eye, they're blind.
Supposed to lock. It's supposed to lock, you know?
Yeah. Well, how long have you been in jail? now?
I've been in jail for, let me see, 7 months.
So we're gonna be given credit for all that term. That will be applied toward this. And
Okay.
you're parolable
Okay.
here based upon the parole law. So we'll see how long that is, but good luck to you, man.
Thank you. Yes, sir. Thank you.
Yes, ma'am.
Have a good day.
Yes, ma'am. Let me see, Miss. Hold on. It's Latonya. Mr. Lib, let me. Okay, we got Latonya. Let's see. Brian Wilturner. And it says feds took the defendant last week. Well,
Yes, sir. He's in.
God bless him.
It's gonna be reset.
oh, yeah, when they're through. We're gonna just take them, huh? They just take them like that, huh? That's Brian Wilturner. Looks like 4 cases, huh?
Yes, sir.
What's he charged with over in federal for?
I don't know.
We don't know. Christopher Smith, please. Is that you?
Yes. Sir.
Oh, come on in.
We just lost Gertz, Judge.
Ma'am,
We just lost Gertz. Did he?
I wouldn't say lost. Is he your lawyer?
Yes.
Ryan Gertz?
He was next door a moment ago, John. I just
Okay.
came from over next door. I was gonna go there for
Oh.
something. There. So he's in the building. He's.
Where were you getting that refreshment? Is there something going on?
There's a
back there?
Starbucks they put in the back there.
There's a Starbucks?
Yeah,
in-
they had a Starbucks back there.
Let me just say the price of those things just went up. Look, Christopher, I'm gonna put you right there back when Ryan Gertz comes back, then we'll pick you up immediately. Okay, sir?
Yes,
All
sir.
right. Thank you. Ralph Smith? No, I'm calling Ralph Smith. He's another name on it.
Not familiar with Ralph Smith.
Okay, so how about Ralph Stephen Ponder?
There you go. That's fine. I'm talking with Mike about it. If you can hold it till.
How's that going?
It's going. Not sure if I'll be able to.
Well, what do you want to do right now?
If
Go
you
to the
just
next
hold it to
thing.
the end of the
Mr.
document.
Reynolds, I've got Kenesha Hawkins.
We're in jail.
This one's nice and thick.
We just lost Mr. Laird on that one, Judge.
I wouldn't say lost. Good, you're gonna take it off.
I
Right?
think it's a sentencing.
It is.
Yeah, so no, sir.
Yeah, well, we better wait for him, but they're in the,
He just stepped out to talk to the probation officer on Ponder.
well, let me go to this next one, buddy, because he's probably.
Mr. Reynolds does have plea that,
Got an MTRP.
Okay.
Please.
Ms. Hawkins, we're gonna put you right there in the box when the prosecutor on this case gets here. We'll bring you back. Thank you, John Laurie.
Yes.
Okay.
That's plea.
Yes. What? I don't have a phone. Oh, there it is. John Laurie is
I believe he's in
in
custody.
custody.
just sent you the plea papers, Judge.
Okay. He's
It's an MTRP. I already have some.
okay.
Look,
You're Mr. Laurie.
yes, Your Honor.
In 25 CR 125, sir, there is a motion to revoke probation that has been filed. You're aware of that?
Yes, Your Honor.
And it was filed on March 30th, 2026. Mr. Reynolds, fine lawyer, has picked this case up. And does the defendant waive a formal reading of this motion to revoke probation? Can we proceed in summary?
He does the court major.
All right. Mr. Lawrence, please raise your right hand. You are John James Laurie.
Yes, Your Honor.
Do you solemnly swear or affirm that any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, Your Honor.
Lower your hands. In summary, this motion to revoke probation states that on November 12th of last year, you were sentenced to 10 years in prison, and that was suspended, and you were placed on regular probation for the state jail felony of theft of property. Is all of that true and correct, sir?
Yes, Your Honor.
And back to the indictment here. Okay, so it was a state jail felony, but it was enhanced to second degree felony punishment, correct? By the two
Yes.
prior convictions, one in 2009, a burglary out of Hardin County, and then another burglary of a habitation out of Jefferson County, Texas in 2014. So what happens, state jail felonies, if you have two prior convictions and if they are in sequence, you understand what that
Yes, Your Honor.
term is. That you were committed a crime, were found guilty, thereafter committed a second crime, found guilty, and those are felony offenses above a state jail felony. Then if you're charged with a state jail that would normally carry with it no more than 2 years in prison, it bumps up because of the prior convictions to second degree felony punishment. Although it remains on the book as a state jail felony, it's still punished as though it were a second degree felony because punishments are based upon criminal history and the circumstances of the crime. Those are the two parts of the equation that make up a sentence of a crime. Okay, so this is a state jail felony punished as though it were a second degree felony and you were sentenced to 10 years. That's why you were sentenced to 10 years in prison, which is more than a 2-year sentence, a state jail felony maximum. And then probated for 10 years. All right, what are we going on? This
2 and 3 on the
Two.
special amendment.
allegation 2 states you failed to provide verification of completing the theft intervention class in violation of condition 27 of your probation order. Is that allegation true and correct as it is alleged?
Yes, Your Honor.
No, it's not right. I knew that didn't sound right. There is no such, we don't have a theft intervention class. We have a theft prevention class. That's about, y'all, that's about the third time I've seen a motion misspelled. All right, I know we're doing fast, we're working fast here. Let me correct that without objection. It certainly rhymes. But
Rhymes better.
all right, so again, number 2 states as corrected that you failed to provide verification of completing the theft prevention class, which is a violation of condition 27 of your probation order. Is that true and correct, sir?
Yes, Your Honor.
Are you pleading true and correct voluntarily and because it is true as it is alleged?
Yes, Your Honor.
What was the other one?
3.
3 states You failed to pay costs, assessed fees for court costs as directed. As of March 10th, 2026, you were in arrears $300, which is a violation of condition 36 of your probation order, which states pay the amount shown in this order in the manner set out in this order. And that's weird.
Should we abandon court?
Yeah, you're looking for all reasons to do that, aren't you?
Yes.
Any reason at all?
In real.
You know, did you pay this restitution of 8,014? Okay. On this allegation here, arrears, were you able to pay?
Yeah.
Were you able to pay and you just didn't pay? Or were you unable to pay?
That's the monthly payments?
Yes, sir.
I was unable to pay at that time.
Well, that's not a violation. If you're unable to pay in good faith, we don't throw you in prison because you were unable to pay. You have to be able to pay, but you have to make a good faith effort. Did you make a good faith effort and were unable?
It's pretty much unable.
All right. Well, I'm not accepting a plea of true to that, but it only takes a plea of true to one violation. And you pleaded true, failing to complete the theft prevention class. We'll go with that. Do you understand that one or more violations of probation, that's enough to grant a motion to revoke probation? Your probation can now be revoked and you can be sentenced no less than 2 nor more than 10 years confinement in prison.
Yes, Your Honor.
Knowing that, do you insist on pleading true today?
Yes, Your Honor.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true. An agreement's been reached where whatever sentence shall not exceed a cap of 5 years in prison. Is that your understanding of the agreement? If I follow this, you have no right of appeal of your case. Do you understand?
Yes, Your Honor.
Out of a race. Okay, what's marked as State's Exhibit 1. Did you sign that document, understand it, discuss it with your attorney, or the contents all true and correct?
Yes, Your Honor.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. This states if I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, Your Honor.
All right, what are we going to do today? Y'all want to make arguments now, or do you want an updated pre-sentence report? I don't know. He was placed on probation here just last November. I don't think one's necessary, is it?
Well,
You waive that or
we
and
we
then
waived
argue?
that, Judge.
Okay,
I wanted
argue.
to bring up
Well-
his situation.
Go ahead. Again, the agreement is whatever sentence shall not exceed a cap of 5 years in prison, which means no less than 2 nor more than 5 years in prison.
Yes.
That's
Judge,
the range I'm looking at, based upon the agreement by the parties.
Yes, Judge.
Okay.
right after the court ordered him to go on probation, he started
How
going
much
through,
time does he have?
started going through a divorce. He also tried to transfer his supervision to Hardin County. And they informed him that it'd be 60, 90 days before it got transferred. And I don't know what happened, but he was unable to communicate with the probation department during that time. He hadn't done his class. Also during that time, he's going through a divorce, lost his transportation, lost his home. Since being arrested on this MTRP, his family has stepped up, and his mother is here in court today. I think she's also written a letter to the court. They're willing to take him in.
Yeah.
And so
Everybody gets to read this. When it's sent to the court, it's not a private thing.
they're
He's asking for
they're willing,
fairness.
if the court will allow him to remain on probation, they're willing to help him, give him a place to live, bring him back forth to the probation office, and make sure that he does everything. He's willing to do that. He'd like to be able to continue and successfully complete probation. He did make full restitution, Judge, and he just got started on probation. I think the court has got his attention. He's been in jail for 2.5, 3 months waiting for this hearing. So whatever he has done wrong, certainly the court has got his attention. We're asking that he be continued on probation.
Stay.
Judge, we did take into account in this offer that he did pay the restitution in full. That's why he's not
Good thing. That
exposed.
impresses me because too often the victims don't get their money back. And in cases like this, it's really generally about the money thing, getting them replaced with that money. It's never because it's lost for a period of time and it's not paid back with interest. They're always out a little bit, but it's all the court rewards people who get the restitution paid back quickly, and which is what you did.
Judge, that being said, given his history, and the short amount of time that he was placed on probation in this case, the state will defer to the judge's opinion on what is fair in this case. But we do think that he was given a very good chance to be given probation in a case like this with his history. And here we are on a motion to revoke, not 6 or 7 months after he was placed on probation. Given that, the state would like the court to take that into consideration as well. The state will defer to the court.
What do you think is in the best interest of the people?
Judge, I think 4 years is in the best interest.
All right. Go ahead, sir. What would you like to say?
Just like I say, I was happy to get the probation because I was actually able to go home with my family, but
oh no,
my family just got torn apart, and I was unexpected, and I didn't know a lot of things that were going on with me and my wife. I had no idea what was going on. So we get the divorce, and I've lost everything. I went into depression, and I just couldn't get it together. I've lost my home, my children, my daughter, first adopted.
Okay.
First of all, see her 2 months.
What's your master plan?
My family, which are sitting there, they're willing to help me out.
Good. But
They
at the
said
end of
they
the
provide
day,
transportation for me to get back and forth to a job.
what are you going to be doing?
Well, actually, a friend of mine and Sylvie were actually trying to buy coastal pools in Beaumont. We're actually trying to get a loan to look at buying coastal pools in Beaumont when they shut down.
Oh.
And but in the meantime, I was going to work for Blue Haven Pools. They offered me a job over there.
What's going on with this burglary case?
That is actually my mother-in-law, my wife's.
Or, I'm just asking, what's the status of it?
It's pending. They have a hold on it.
Well,
Yes, Judge, it was indicted in March.
Was it indicted?
Indicted in March.
Well, a grand jury's found
Well,
probably cause to
he's got to face those charges. Yes, sir.
and that's a second-degree felony, and they're going to. It's indicted.
I was.
Oh boy.
Yeah.
See, you're looking at habitual felon.
Yes, sir. Well,
That's 25
that
to life
case
if they-
was used to get me to sign a mediated agreement and divorce.
Nonetheless, the grand jury doesn't. That's not the way they.
Yes, sir.
They don't look at that. They look at what's presented to them by the state, and
Yes, sir.
but you're looking at a pending 25 to life, a
Yeah.
minimum of 25 years in prison.
And that's why another reason why I was trying to get put back on probation, just to try to get things right, try to move forward and try to make everything correct and make everything right. And be able to fight this case also.
How do you do it? How do you do that? He's fighting this case or that case?
That case, and just try to get back on probation and try to do things right, try to do things right for my daughter. Enough.
Well,
I've got a lot wrong direction a lot of times. And 15 years of marriage, I'm finally out of that toxic relationship that I was in, and just trying to start over.
Okay.
Which is what I'm doing, starting over completely.
right, this indictment alleges a burglary of a habitation conviction in '09 out of Hardin County. Another burglary of a habitation conviction in '09 out of Hardin County. After that was finalized, committed another burglary of a habitation and were convicted of that in this court, right?
Yes, right.
And put on probation. And then, so now there's a fourth burglary of a habitation pending.
And that could put me away for life.
Oh, yeah.
Absolutely.
Yeah, but that's two convictions ago, you were subject to life.
Yes, sir. And I've been,
What's probation, thought? Because you're always influential.
Well, of course, Judge will follow the
You're
direction.
often nice.
Um,
How about,
however, when Mr. Laurie was requesting courtesy supervision in Hardin County, he failed to report for his intake on December the 17th. They rescheduled the intake appointment for January the 20th that he failed to report as well. I also made a due diligence call to Mr. Laurie to try to find out what was going on, why he wasn't reporting, and I couldn't get in contact with him at all. So it just, at the end of the day, he wasn't making an effort.
and I'm a bit background, I was in a bad spot.
Hmm?
15 years of marriage just gone on the toilet, and I just lost everything.
you can, hold on. My parents got divorced and they picked up the pieces and were able to carry on.
That's what I want to do.
Here's the deal is you keep using that, but what does that have to do with committing crimes and not reporting? I mean, that's serious.
I can't say much about
I mean, look, divorce, failures of marriage happen too often, but that's not, it's not in the penal code as an excuse.
Just really.
Oh,
No, so
okay.
it's just.
All right, here's what
I
the
just
court's
want to
gonna
start
do.
over.
Sir.
I just want to start over and try to see.
Yeah, well, never too late to start over and pick it up and head in the right direction. I'm going to try to help you on that. There is sufficient evidence supporting this motion to revoke probation granted by preponderance of the evidence or greater, as allegation 2 has been proven true, that you failed to provide verification of completing theft prevention class. And did he ever go at all on that? No. And which was a key thing, especially in light of the numerous burglary convictions and this new burglary charge and the fact that you were placed on probation for theft. Okay, so the court finds that there is sufficient evidence to grant this motion to revoke probation. Your probation is hereby revoked, and you pleaded guilty to this state jail felony, punished as though it were a third-degree felony because of the prior felony convictions. You were sentenced to 10 years in prison, and that was suspended. You were placed on probation for 10 years. Was it one case?
Yes,
Two cases.
Two cases, one's going to be dismissed if it hadn't already.
Is this sentencing today?
Yes, sir.
Okay, because she had pleaded guilty earlier in 23-41581, injury, first-degree felony, injury to a child. And
I've got 5182, or 1582.
23-41582.
Is the injury to a child first degree, both of them?
Okay, there's sentencing hearing on both of them?
No, sir. Just one of them is going to be dismissed. We're doing the sentencing on 1582. 41582, sorry, 41582.
Okay, yeah. Everything got put in the other, taking all that out. What happened here? Okay. Yeah. Okay, already on it. 23-41582 is now called the state of Texas versus Kenesha Hawkins. That's you, correct?
Yes.
With your attorney, Mr. Reynolds, and the state's attorney. Earlier, you pleaded guilty to the first degree felony of injury to a child in this cause number 41582, causing serious bodily injury to a child 14 years of age or younger by failing to take the child to a medical treatment facility after it was apparent the child needed immediate medical intervention. And you had a duty as parent to take care of that child. A pre-sentence report has been prepared. If the parties had an opportunity to review it, are there any corrections or changes to it? State
Not from the state.
and defense. All right, then the pre-sentence report is made a part of the record for all purposes here. The agreement in this case is whatever sentence shall not exceed a cap of 40 years confinement in prison. So we are looking at, correct me if I'm wrong, no less than 5, no more than 40 years confinement in prison. Deferred or unadjudicated probation is an option or not?
I think so.
I believe it is.
Is regular probation an option on this as well?
I think so.
Yes, sir. There's no
Injury to a
deadly
child.
weapon. There's no deadly weapon. So. we'll
All
make
right,
sure.
so there are 3 options here as I
The
understand.
3G offense. I don't know.
Yeah, I don't think it may be under the maybe a limit since there's a decibel. I said, what the number that's. If it's under A1, it's you can't give a straight probation. Under 42 L 54 subsection A10. If it's a first degree and the victim of the offense is a child, then you can't.
And that's what this alleges.
Yes, I don't believe you can give regular probation.
So it's just the 2 options are deferred or unadjudicated probation and flat time.
Yes.
Is that what everybody agreed? This is 22 and 4. 14 years of age or younger.
I don't see anything under the eligibility for deferred.
Where were you on the
42A 1102. I don't see a 24 under that subsection.
So you're stating she is eligible for deferred
Correct. I think she is.
or unadjudicated probation. But not regular probation under 42A.054. The state and they go open and close here on the argument.
Judge, I have one witness that would like to testify. Call Frank Coffin from the Beaumont Police Department. He's present in the courtroom.
Come forward. Raise your right hand, sir. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. She can come up here.
Coffin, Coffin, third.
Oh, yeah.
Detective, how are you employed?
I work for the Beaumont Police Department
And how long have you worked for them?
since August of 2002.
And were you the person who investigated this injury to a child that occurred back on September 29th of 2022?
Yes, sir.
And at that time, when the investigation started, I know that it wasn't apparent what was going on. Is that correct?
Not immediately, no, sir.
After a little while, though, did you start getting some conflicting stories from the defendant?
Yes, sir, we did. We were able to interview the defendant over approximately 16 hours, and we had received many conflicting stories.
Did you also get conflicting stories about that contradicted what she said from other witnesses?
Yes, sir, we did.
And during these stories, was there anything that caused you concern about whether or not she had actually caused the injuries to this child?
Yes, it became clear that she'd caused the injuries to this child.
Now, she did not plead to that in here. You understand that?
I do understand.
Were there several people that you talked to that aunts and other relatives that tried to get her to take the baby to the doctor?
We extensively spoke with all the family members. By the way, she has a great family. They're solid people, her aunts and her father, some of the best people that I know dealing with investigations. And they all urged her. They saw that this child was in severe distress and urged her to take her to the doctor.
Now, it turns out the doctors came up with, and the judges looked at the pre-sentence report, that the baby had developed sepsis. Is that correct?
Yes, sir.
And when looking at the way that the defendant was handling this, did she appear to be distraught over what was going on with her baby?
No, sir, not at all.
Did it appear to you that she was just trying to be deceptive throughout the process?
Yes, sir. She did not want to be caught as the one that had done this.
Was there something when the baby was at the hospital, even at the hospital, was there something that the mother was she showing concern at the hospital?
No, as a matter of fact, she called the doctors liars.
Was the baby on life support almost the entire time it was in the hospital?
The entire time. The doctor said that the baby wouldn't survive off of life support. And ultimately, that's what happened when they removed him.
Talking to the doctors, could this baby have been saved if it had been taken to the doctor after the injuries?
Immediately after, they said that there was a very good chance that the baby would have been saved.
Now, y'all worked diligently on this case over many, many months, didn't you?
This is the only thing we've worked on for myself and my partner, Sergeant Keene. This is the only case we worked on for about 3.5 months.
And is the reason for that because of the first of all, that this was such a young child?
Absolutely. And it was, of course, such a young child. And she tried to lay blame to so many different people to cover her tracks that we had to clear that.
So you had to go through and rule out every story that she gave, is that correct?
Every story she gave, she tried to say, Judge, that all of her aunts had done this to this baby instead of her.
And you've seen the story she's come up with this time, right?
This late stage false fabrication that she's come up with now directly goes against the doctor's findings, our investigation, and her own previous statements that she's made to us over repeated interviews.
So was there anything that she ever said that came out to be true when you were doing this investigation?
The only thing that she said is that was truthful is after a period of time, she said that she knows that she should have brought the child to the doctor because it was in severe distress.
Anything else you want to add that you wanted the judge to?
Just one other thing, Judge, I was hoping that with this late false narrative that she's given directly goes against what I would think to be to show that she's really sorry for this and to show, some character. But I guess I was wrong. We've never heard anything about some teenager and falling down the stairs. Nothing like that. As a matter of fact, she said that she put the baby in the crib before the baby had the medical incident, and the baby was fine. Said she drank 3 bottles of milk and was playing and cooing, where the doctor said that was impossible. The doctors at UTMB, Judge, said this was the worst case of eye damage that they'd ever seen. They said that the first doctor that looked at this didn't know what she was looking at and had to get another physician to come in to make sure that she was right of the detached retinas in the baby's eyes.
You've dealt with a lot. How does this one rank?
This is one of the worst cases I've ever seen, Judge.
Thank you. I'll pass the witness to it.
The baby was brought to Baptist Hospital.
Yes, sir.
By the mother? Or by EMT?
Are you talking to me?
Yes, yeah, to you.
Okay. Yes.
And the doctors there at Baptist Hospital examined the baby, didn't they?
They did.
And the doctors said that they couldn't find any sign of trauma at the Baptist Hospital.
At first, they did tell us that, but once the baby got to UTMB.
Okay, well, I'm talking about Baptist Hospital.
Yes.
And they have fine doctors there at Baptist Hospital, don't they?
I can't talk about the fine doctor.
But the
doctors missed it.
The doctors missed it.
Yes, clearly.
Okay. And now my client is not a doctor. Clearly. Okay, so she missed it and the doctors at Baptist missed it, but they picked it up at UTMB. Yes?
Yes.
Okay. Pass the witness, Judge.
Detective, they didn't miss the sepsis though, did they?
They did not.
The baby was actually, the heart had stopped. Is that correct?
From the sepsis, from the violent attack that had been on this child, the sepsis caused the medical incident that occurred.
That was in the forensic pathologist looked at it and found that that's what caused the actual sepsis to occur. Is that correct?
Yes.
Injuries. And that the fact that the doctors missed the injuries, they didn't miss the sepsis when it got
They
there.
did not miss the sepsis.
That's what they were treating it for when it first got there. Is that right?
Yes, sir.
To save its life.
Yes, sir.
Pass the witness. Anything else?
No further questions.
Okay. Thanks, sir.
Thank you.
What else? You stay. Just argument, Judge.
Okay, go ahead. Yeah, and by the way, for the record, the pre-sentence report is made a part of this hearing for all purposes. And there is a there's a letter here from a Desica Hawkins, who is writing on for her sister. That's your sister.
Yes.
And this is in the court's file that the court has read. And then Anthony Hawkins wrote something, and Mr. Hawkins is your father?
Yes, sir.
Not, he's not a stepfather, he's your
He's my father.
natural
Yes.
father. Okay. I think I got that. Okay, I think those are all the supplements to the pre-sentence report. Go ahead, State. You can go begin and end.
Judge, when you read this pre-sentence report, it's long, and it's long because there's a lot of facts to this. There was a lot that went on and a lot of things that this defendant could have prevented. And I'm going to stick with the not taking the baby to the doctor. According to the doctors, when it got to UTMB, that there's no way this baby was fine, even just hours before the baby stopped breathing and having seizures and things. It was apparent that this baby had been sick for a while and it was seriously ill. And they did everything they could to try to save the baby, but the baby, I keep calling it baby, Jacaden, was dying, and was dying because the mother, who lied to her relatives, who said try to take her to the doctor, she told her boyfriend or her friend or neighbor upstairs that she had taken him to the doctor when she hadn't. We had all the doctors check, and she canceled the appointments for the baby. She did everything not to take care of this baby. And that's what a mother's supposed to do. And that's why in this particular instance, it's just a shame, because this baby was only 6 months old, 7 when I think Jacaden died, but Jacaden was only a little over 5 months old, almost 6 months old whenever this happened, and then 7 months old when the baby died. And it's sad because Jacaden depended totally on the care that was given by his mom, and shouldn't have had anything happen to him. There's no record of anything going on specifically in the mom's life, except at that time, that weekend when that baby was injured, it was around that time that he was injured, was her birthday. And she wanted to go out and spend a couple of days for her birthday. So the defendant, went out and had a great time. When the baby became sick, baby was throwing up, having issues, and she did not take it to the doctor when she should have. And Jacaden stayed in the hospital even after the baby. Jacaden is in the hospital, and mom can do what's merciful and take Jacaden off the life support. She refused, and they had to actually take action to get the father to be able to take this child off the life support, because it had been deceased for weeks and was just laying there. While that's happening, there's a video of her out twerking at a bar one night while her baby's still on life support. And then when she gets arrested and thrown in jail, instead of showing the remorse and acting like the nice person that she is, you've seen the jail records. You've seen the comments about the disciplinaries that she's had over the last few months in jail, where she just keeps acting up. She's not a good person. She's not a person that goes in and does what she's supposed to do and follows the rules, and just takes care of business to show respect for what is going on and the gravity of the situation. It's all about her, Judge. This whole thing, every time I read this, and I've read the offense reports, I've gone through everything, I've listened to her statements over and over, and all I hear is it's all about her. Not about Jacaden, but about her. Thank goodness her other children have been taken away, and she's not going to have those. And I think that I wish we'd have taken Jacaden away, but we didn't know until it was too late. But I asked this court to give her the 40 years. I think it's a fair offer. I don't think there's anything less that could be fair in this situation.
All right, for the defense, go ahead.
she has no criminal history, Judge. And from day one, Ms. Hawkins has always, at least to me, been remorseful about what happened to Jacaden. And she accepted responsibility for not bringing him to the doctor in time. And as a mother, she's lost her child, and she lives daily with the fact that she didn't seek the medical attention that maybe could have helped or saved his life. Also, Judge, at the time that the case happened, at the instant that she called EMTs and brought her child to the hospital, to Baptist Hospital, the doctors, the professionals, could not find any evidence of trauma. They found evidence of sepsis. And these are trained doctors with CT scans, and they couldn't figure out what was wrong with the child. And they sent the child to UTMB, which in the end turned up severe, lingering, chronic injuries to Jacaden. Now, my point is, if the doctors can't figure out what's wrong with the child, how could Ms. Hawkins figure out what was wrong with the child? And she knew there was something wrong. And as a mother with protective instincts, she feels she let her child down. I think 40 years is severe, but she will accept responsibility. And I think the court should go to maybe the lower end of the range. And Anisha, you want to tell the judge anything?
Yes.
Okay.
The statement Detective Kaufman just made was absolutely not true. And my family is here in the court today to attest to that.
To what? To
That they did not urge me. They thought the same thing that I thought, that he was teething. We did not know that he was hurt.
he was teething?
Only thing was wrong with him that he was showing signs of was irritableness. Irritableness. That was it. He did not show signs that he had an internal injury that could cause his death. That is absolutely not true. My family has 100% supported me. They never went against me on that. Ever. They did the same thing 3 days prior to my birthday, which was September 22nd. He went with them. He went with them on actually my birthday was September 22nd. That was a Thursday. He went with them on September 23rd on a Friday. He was there from September 23rd to September 25th. They had him in their care. If they ever felt like he needed immediate medical attention, they would have took him themselves. They got Oragel and Tylenol because they thought the same thing that I thought. I never lied to Detective King. I did not. At the time, going through the process, I was numb to it. My child is in the hospital. I don't know. That's all the shock. I'm numb. I'm not even in my body. I'm not even here. I don't think this is really my life. So yes, some details I forgot to tell him, like I left him with someone for 2 hours. But I always told him, the question he asked me was, did my children handle him? My children at the time were 5 and 2 years old. My children never handled Jacaden. The children upstairs, the teenager and the 8, 7, and 6-year-old did.
Oh, so it's somebody else's fault? Children?
No, I don't blame anybody. It's my fault for allowing them to even take
They
it out
the
of my
ones that
eyesight.
caused the injuries? The
The
children
children
caused.
the
Hold
trauma,
on, let
the
me
fault.
speak. Let me speak. She can't take down everything when two people are speaking at one
Yes,
time. I'm
sir.
going to ask you questions on this so that we can kind of have a dialogue. Are you saying someone else caused the injuries, not you?
My choice of allowing someone to
I'm
handle
asking
him.
you just yes or no. Are you saying someone else caused these injuries, not you?
Physically, yes, sir.
Who?
A child.
Which child?
Children.
What child?
Upstairs neighbors, and I told them that they could go play back the video to see them taking him upstairs and then bringing him back down and telling
Did you
me.
see them harm the child?
I wasn't in the house.
Did you see them harm the child?
No, sir, I wasn't in the house. They came back and told me
How
that they
long did they
dropped
get
him.
the child?
About 15 minutes, 20 minutes.
Okay. Keep going.
I take full responsibility for not getting my child to the hospital. I take full responsibility for making me out to be this monster. I hurt my child. I didn't care. That's a lie. That's a lie. And of course, I'm a mother. I'm losing my child. I don't want to take him off life support. I couldn't make that decision. I could not make that decision. I didn't want to let him go. I did.
So what about that?
That's what they said. I made the selfish decision of not taking my passport. That was the state statement. That's not true. I just could not let my child go because I
What
was
do you mean you couldn't? Is that why you didn't bring the child to help, to medical?
He was hurt.
Is that what you're saying? That was why you hesitated bringing the child for medical help?
Yes, I didn't know.
Okay, I didn't understand what you were trying to say.
I didn't know. I didn't know he was hurt. I did not know.
Okay. What else?
I've been a single mother since I became a.
A lot of single mothers are out there.
I've been a single mother. I've never had an instance where any of my children have been hurt or anything like that. This happened with Jagaden. And I blame myself every day for allowing the things I didn't allow with other kids. I'm not a monster. I'm not a monster. I don't hurt my kids.
Let me ask you, how old was the child when this happened?
He was 5 months old.
5 months.
Yes.
Yeah, there's some parts here in this report that say 7 months.
That's
wrong.
That's when baby died.
I think
It's 6 months.
he was in the hospital for a couple of months.
He was in the hospital for
Yeah,
a total of a
trauma
month.
of sorts. Okay, go ahead.
I'm just not a monster. And my jail behavior is me defending this because people are going along with what's been put on the news. So I'm defending this. I'm not what they trying to make me out to be. I've never been in trouble. My kids have never been incarcerated. Like you said, I have an amazing family. I have the support. I'm not a problem. I'm not a problem. But I take full responsibility for the misjudgment and mistake I made by not taking the time to speak.
All right. Anything else you'd like to add?
No, sir.
Okay. Here's the presentence report, which has been presented and is part of the record, which was introduced and made it part of the record without objection. Court is going to refer to a couple of these. And what we're dealing with is medical science here. This isn't a soft science. This is a hard science, medical science. So this states that the detectives interviewed you at the hospital where you provided information and initial where you provided no information about any recent injury or significant illness. Initial medical assessments indicated a severe blood infection, which I guess that's what you had told the authorities, that there was a blood infection or something?
No, that's what they found.
Well, they indicated a severe blood infection with no obvious external trauma, suggesting the case might be medical rather than criminal. Nevertheless, standard procedure in child death and severe injury cases, then the authorities then further researched this matter, and the detectives went to the residence where the child was living. And this states that the bassinet's padding was heavily soaked with liquid far exceeding what would be expected from a single infant's urination. And a preliminary forensic assessment was made over the following days at John Seeley Children's Hospital, which diagnosed the child with severe abusive head trauma. Dr. Patricia Beach, pediatrician and forensic child abuse specialist there, documented bilateral widespread retinal hemorrhages in all layers of the child's eyes with bilateral retinal detachment and subdural brain hemorrhages, intracranial hemorrhage with traumatic encephalopathy and very significant injuries overall to the child. The doctor noted that the symptoms were compatible with head trauma. The child's condition deteriorated rapidly, became comatose, was placed on child support, and because of the diagnosis of severe brain injury, became clinically brain dead with no hope of recovery, and was rendered blind by the extensive eye damage. He also experienced multiple organ damage due to oxygen deprivation. This was, according to the doctor at John Seeley, the worst case of detached retina ever seen, along with more than one area of bleeding on the brain. The doctor later explained to investigators that Jakaden suffered severe sepsis caused by intestinal bacteria leakage, which stemmed from brain injury that impaired the organ to function properly. She demonstrated that the injuries resulted from violent shaking, which lasted 60 to 90 seconds and placed the most severe recent traumatic event between September 20th and the 22nd, which was just a few days before the child's death. Dr. Beach confirmed that the CPR performed by the officers could not have caused any of the injuries and suggested that early medical intervention could have improved the outcome. A skeletal survey performed later revealed numerous fractures to various stages of healing. These are old injuries of healing across multiple ribs, arms, legs of the child, indicating repeated episodes of extremely violent shaking over time. Dr. Beach concluded that the constellation of injuries, severe brain hemorrhages, retinal hemorrhages, eye detachments, and multiple fractures of the child's body was highly indicative of abusive head trauma inflicted on more than one occasion between the months of August and September. The Galveston County Medical Examiner, Dr. Barnhart, reviewed the autopsy findings and similarly determined that the injuries were consistent with abusive trauma. On October 30th, a few days later of 2022, the child was removed from life support. And the child died.
Judge, there's one real important on page 2. That third paragraph, which starts off with however, in that sentence, about the second sentence down. Each aunt provided consistent accounts of the child's symptoms, including green vomiting, fussiness, fever, labored breathing, which they repeatedly urged Hawkins to address medically. Hawkins repeatedly minimized or denied these symptoms and claimed that she had sought medical care. Statements later disproven by phone records, text messages, medical office confirmations, and witness accounts.
That is included in paragraph 3 of the second full paragraph in page 2 of the pre-sentence report. So three of the defendant's aunts who cared for the child each provided consistent accounts of the child's symptoms. They repeatedly urged the defendant to address them medically, and the defendant repeatedly minimized or denied these symptoms and claimed that she had indeed sought medical care, which was a statement later disproven by phone records, text message, and medical office confirmations, as well as other witness accounts. Picking back up, the defendant's behavior on the evening before Jacaden was removed from life support and died was captured in a short video obtained by the investigators. The video showed the defendant dancing at a nightclub. When confronted with the footage during an interview, she confirmed it was her who was dancing and responded that, "What's your point?" When informed that the video was taken on the night immediately preceding the planned removal of her critically ill infant son from life support. The investigator states that such behavior stands in stark contrast to the image of a grieving mother that she had otherwise presented to investigators and medical staff. And it certainly contradicts the way you're talking about what happened to me. That was true. You were dancing the night away, but before the child is clinically rendered dead.
I do not think that was the night before he was taken off.
I'm sorry, that's what they say.
I don't remember. It was.
You don't, now you don't recall?
I'm saying I don't remember when it happened.
I think things like that would be probably blazed into your memory, wouldn't it? I mean, isn't this important?
Judge.
Oh. So the pre-sentence report from the probation office states in summary that the incident reports document a lengthy and consistent pattern of disruptive, aggressive, and non-compliant behavior by the defendant throughout her incarceration from February 23 through May of 26 at the Jefferson County Correctional Facility. The defendant repeatedly refuses to follow oral and written directives, argues with staff, creates excessive noise, openly disregards institutional rules. Her conduct frequently escalates into verbal confrontations with both the officers and other inmates, and on many interactions include hostile, profane language and personal insults directed to the staff. The reports describe multiple instances in which you instigated or actively participated in physical altercations. These include fights involving the throwing of objects, striking other inmates with closed fists, stomping, or attempting to advance toward others despite officers' attempts to restrain you, and in several instances, spitting on other inmates. Several fights required staff intervention through physical restraint, spray deployment, and on one occasion, the use of a taser when all other measures failed for you to gain compliance with the rules. You are also frequently involved in group disturbances, either as an instigator or an active participant, contributing to heightened tensions and unsafe conditions within the dorms and recreation yards at the jail. In addition to aggression, you regularly violate procedures and security rules, including entering unauthorized areas, refusing to rack up, go to bed during required times, returning to the dorm without permission, engaging in unauthorized communication with inmates in other areas, and failing to wear your uniform properly. There were repeated disciplinary actions for possessing or creating contraband, such as extra bedding, hidden razor, tattooing implements, ink containers, and a self-inflicted piercing. Reports also note instances of hygiene violations, unauthorized use of equipment, and attempts to evade or undermine officer authority by influencing other inmates or encouraging noncompliance among the dorm population. Many officers report that your behavior often disrupts institutional operations, including medical pass, chow, head counts, and normal dorm functioning. Your conduct is repeatedly described as inciting other inmates, creating hostile or unsafe environments, and contributing to escalating conflicts. And several reports portray you as openly dismissive of consequences and frequently stating that you did not care about receiving write-ups or restrictions. In later reports, officers have expressed concern that you demonstrate no sign of rehabilitation, continued endangerment to others, and attempting to intimidate the staff and some other officers, describing your behavior as hateful, threatening, or intentionally defiant. All right, well, those aren't going to get you gold stars. Anything to add? to add by any of the parties?
Yes.
Anything, Ms. Hawkins, you would like to add? You get to speak last. If nothing further, the court is going to follow this agreement of a cap of 40 years confinement. So within that, we are looking at no less than 40, no more than 40 years confinement in prison. And the how did we ever decide on the deferred or unadjudicated probation?
I believe she's eligible.
She's
Eligible for that, but regular probation is not an eligibility.
Correct.
Okay. The defendant has pleaded guilty voluntarily to this first degree felony of injury to a child by causing serious bodily injury to Jacaden Shaw, a child 14 years of age or younger. And actually, we now know that the child was 5 months here on this earth at the time of the child's death. And the defendant is accused also in this indictment that she pleaded guilty to of failing to take the child to a medical treatment facility or to a medical professional after it was obviously apparent that the child required immediate medical intervention. And what's more, under law, the defendant had a statutory and legal duty to act responsibly and timely as the defendant was a parent of the child. And this states that is a crime of first degree felony injury to a child against the peace and dignity of the state, signed by the foreperson of the grand jury. And there was sufficient evidence supporting the defendant's guilt from State's Exhibit 1 admitted at the hearing where the defendant pleaded guilty voluntarily, knowingly, intelligently, and with legal advice and legal assistance. There was enough evidence presented to support the defendant's plea of guilty to find the defendant guilty of this first degree felony of injury to this child of 5 months of age. This court now finds the defendant guilty beyond a reasonable doubt of this first degree felony injury to a child. The court is following this agreement of whatever sentence shall not exceed 40 years in prison. And this court, who has 2 children, 3 grandchildren, knows intimately that children are 2 things: gifts from our Creator, number 1. Number 2, that as infants, they are helpless to take care of themselves. And that's why we have not only a legal duty, but a spiritual duty to take care of children, especially children as young as 5 months of age. This court has read into the record innumerable circumstances where you have absolutely failed and neglected your responsibility given by our Creator and our law. I now find you guilty beyond a reasonable doubt, and you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 40 years confinement. The death of a child, what is the cost? What is the right punishment? A child's loss is maybe the greatest loss that humans deal with on this planet. And I can't say enough about the special treatment that must be given to children from our Creator. And you totally failed, and not only failed, but attempted to blame others for your irresponsibility. I just wish we could have somehow, before this happened, convinced you of the importance and the responsibility that you had to your child and how that was vital to the child's existence. This is the order of the court, and we are in recess on this case. Here's this one. Y'all, what do y'all have?
I'm Mr. Fontenot, the judge. He's gonna want a trial.
Who?
Kelly on the Fontenot.
Hey, John, let me, Ryan, anybody, there you go. On, what are we gonna do on Christopher Smith?
Judge, we're asking for a Zongo setting on that. He's got a
Okay, I need some files.
potential federal indictment, and until we know what's going to happen with that.
Okay,
we know-
how long?
I mean, 2 months.
We doing, is that good?
Yes, sir.
We're doing 2 months.
Just a
Okay,
file.
agreed
So,
by the parties. Reagan, on Ralph Ponder,
Judge, we have agreed to amend his probation conditions, so his motion to revoke probation will be dismissed.
okay, that's, I guess that'll be submitted to me, huh? On Ralph Ponder. Oh, you have it? Okay, thank you. And this is on 17-283-5-8-17. How long is he
Yes,
on
sir.
probation?
Since 2018,
He's about,
he's almost done. He's got about a year and a half left.
he's gotta be a senior in probation school.
Trying to graduate.
any issues with that file?
Yes.
Okay. Yeah, I said in the dismissal already.
Yeah, it's and then I believe the dismissal is in your queue on your tablet. So
The what?
the dismissal of the motion to revoke probation.
Good news, then.
That's down on him. Left hander, and then it smudges. Okay, that's that.
Judge, I did have.
You know what? I had cases on Tanisha. What did I do?
Is this the That's, I believe they said it.
I had,
Mike.
hey, Mike, I had 2 cases on her.
Yes, sir. I got to dismiss the one.
You're gonna dismiss
Yes,
the
sir.
other ones. Okay.
On Christopher Smith, Judge, I have in my note that it's going to the grand jury for the feds on July 7th, in case you want to note that.
Okay. There's not much I can do about that. Yeah. That's, whatever you say. Taviante Fontenot?
Yes, sir. I mean, I'm working with Mr. Hannon on the plea, but Mr. Fontenot doesn't want the current plea.
I thought it was set for, so I thought that tricked out.
No, I think there was a misunderstanding of what we were trying to do. Sorry, Judge.
Hold on.
It's raised sex.
I think we had.
Get him out.
Yeah, there was discussion about going around. No, we weren't.
And then I have Shaquille Maxon.
Your Honor, that case is, there's an additional charges coming on her. This, I wanted to.
What do you want to do?
How, Wisconsin, I can get that, make an amendment.
On Shaquille Maxon, reset that?
Yes.
Yeah.
For what? For review in 3 weeks?
Yeah, fine, yeah.
Okay.
They're asking.
Maxon, reset 3 weeks, okay.
Tyler.
Jeremy,
He's not here, he's in an institution with his.
okay. He's not here and we're waiting on, we'll reset it.
Well, no, it's a recommitment, mental issue.
Well, what do we need to do?
I think we should put on the record that just he's been, we have a doctor's report back in
One of those where just, the doctor sent reports in.
Anyway,
Then he needs to be recommitted.
Jeremy Tyler.
Yeah.
There it is. Okay. Jeremy Tyler is now called in cause number 235872. The State's Counsel and Mr. West, Defendant's Counsel, are present. Earlier, defendant was found not guilty by reason of insanity in October of 2022, and we have regular meetings on and hearings on this matter to determine the status. And we have received a collection of documents from the Texas Health and Human Services Center in Rusk State Hospital. And it includes one, two, three, 4 pages of a cover page and a forensic psychiatric report signed by Dr. George Howland, unit psychiatrist at Rusk State Hospital, and Matthew Gallagher, superintendent of Rusk State Hospital. And 1, 2, 3, those 4 pages recommend that Mr. Tyler be recommitted to Rusk State Hospital for further evaluation and treatment at this time. And there are physician's certificate of medical examination for mental illness signed by Dr. Howland, dated May 27th, 2026. That is part of the package sent by the Texas Health and Human Services. And Dr. Howland states that he evaluated and examined Jeremy Tyler on May 27th, 2026 at Rusk State Hospital. And the defendant continues to be diagnosed with schizophrenia, inhalant use disorder, and cannabis use disorder. And that the defendant is suffering severe and abnormal mental, emotional, or physical distress, is experiencing substantial mental or physical deterioration of his ability to function independently, which is exhibited by the patient's inability, except for reasons of indigence, to provide for his basic needs, including food, clothing, health, or safety, and thus is unable to make a rational and informed decision as to whether or not to submit to treatment. So, it is the opinion of Dr. Howland that the patient is ambivalent at times, that he has mental illness, does not think he has substance abuse history, does not know post symptoms, does not know his past symptoms, and needs more time to gain insight with further treatment at Rusk State Hospital. And this includes a waiver of trial by jury signed by Jeremy Tyler. I've always wondered how those are important and have relevance when someone is deemed incompetent. But nonetheless, he is involved in the process, and that's what the law requires. So the court is going to, unless the parties have something else to say, continue his mental health treatment at Rusk State Hospital, and an order will be submitted in that regard. Any objections?
No objection on the defense.
No.
All right, that will be done. Thank you. I'll take that to Lacey, who will get that over. All right. Folks, yes, please come forward. Who is this now? Mr. Who?
Comments?
This, Pabiante? 2 cases. Mr. Fontenot. And I've got Mr. Fontenot here on 24 CR 281, charged with 3rd-degree felony, prohibited, having a prohibited weapon, namely a machine gun, and that carries with it up to 10 years in prison. Then 24 CR 1605, is a second-degree felony indictment for aggravated assault with a deadly weapon. And yeah, these occurred on different dates in January of 2024. So you're looking at up to 30 years in prison on all of this. I don't see any prior convictions in the indictments. I don't know what that does to anything. And what are we doing today?
Judge, we're setting you for trial because Mr. Fontenot doesn't meet the current candidate.
The defendants never want it. It's just whether they are agreeable to it. You're saying that that's not going to work.
Correct.
All right, you know, okay, what we'll do is we'll try this second-degree felony first and then go to the third-degree felony thereafter. Each of those can be stacked on each other since they occurred on different days if you're convicted and sentenced. And that's what we will do. Then that's your last chance. All right. Set for trial, no deals. Next is what? Who do I have? Who do I have? Anybody else? Joe Stone? We took care of that, didn't we? Huh?
That was the dismissal.
That was the dismissal?
Correct.
I have a John Laurie.
We did that one already.
This thing doesn't sign for some reason. What do we do now?
You sentenced him to 4 years.
Hold on. This is 25 CR 125.
Yes, it was a cap of 5 years, I think, and then you sentenced him before.
Okay, sign on this. Sign it, see the cap, yeah. Okay, what I didn't do is. Submit that thing over to you.
Okay, I felt you said. We going this way, this way. And regular TWI, wash it off.
Okay. Is it over? That's all right. Anything else? Yes.
His name is Mr. Watkins. I'd like to talk to him.
About?
Say hi.
You, Mr. Watkins?
Yes,
What do you need, sir?
Nothing from you, sir. Just saying.
Nothing from me. Well, that's a first today.
Well, you're a bit of an inspiration, actually.
Really?
Yes.
I've never been called that before.
Well,
I
I have no reason to pick up.
What's up? Yes, sir.
Just
Hold on, stand by.
YouTube feed and
Here, let me get this off. We're on YouTube right now. Let me in there. So we have.
What started as a sentencing hearing for a child abuse case quickly became one of the most emotional courtroom moments of the day. The defendant had already pleaded guilty to a first-degree felony involving the death of a 5-month-old child. According to the court, the case wasn't just about what happened to the infant, it was also about what failed to happen. Prosecutors argued that the child desperately needed medical attention, yet the defendant failed to seek help even when it became obvious that immediate treatment was necessary. As the judge reviewed the facts, the courtroom grew silent. The court explained that parents have both a legal and moral responsibility to protect their children, especially infants who are completely dependent on adults for survival. The judge emphasized that a 5-month-old baby cannot ask for help, cannot seek medical care, and cannot protect themselves from danger. That responsibility belongs entirely to the parent. Then came the moment that changed everything. After reviewing the evidence and the guilty plea, the judge found the defendant guilty beyond a reasonable doubt. While there was an agreement limiting the maximum sentence, the court still had the authority to decide the final punishment within that range. The judge stated that he had read extensive reports about the case and believed the defendant had repeatedly failed in her responsibility to protect the child. The judge's words became even more emotional as he reflected on children and the duty parents owe them. He described children as precious gifts who depend entirely on adults for care and protection. According to the court, the tragedy could have been prevented if proper action had been taken when the child first showed signs of needing urgent medical help. Finally, the judge announced the sentence. The defendant was ordered to serve 40 years in prison for the death of the 5-month-old child. Before ending the hearing, the judge expressed sorrow that no sentence could undo the loss of a child's life. He stated that losing a child is among the greatest tragedies a family can experience, and wished someone had convinced the defendant of the importance of her responsibilities before it was too late. By the end of the hearing, one message was impossible